Hello again, my lawyer friends. Rule 1.7 is titled Conflict of Interest, Current Clients. This is not just an ethics issue, but also a malpractice risk. So you definitely want to make sure you understand this rule. Stay tuned, and don't forget to hit the subscribe button. There are two basic things you need to know, and a few subtleties. First, a lawyer must get informed written consent from each client before representing a client whose interests are directly adverse to the interests of another client. It's important to note that the two clients' interests can be adverse in the same or even separate matters. So you have to consider whether a new client's interests conflict with any other client, and matter includes not only litigation, but also contracts, transactions, and a variety of other situations. Second, a lawyer must get informed written consent from each client before representing a client where there is a significant risk that the lawyer's representation will be materially limited by the lawyer's responsibilities or relationships with another current client, a former client, a third person, or the lawyer's own interests. Note that this rule does not prevent a lawyer from taking inconsistent legal positions, provided that there isn't a significant risk that the lawyer will temper their advocacy on behalf of one client to avoid creating adverse precedent in another client's case. Even where there is no significant risk that a lawyer's representation will be limited, a lawyer must provide a written disclosure where the lawyer has or knows that another lawyer at the lawyer's firm has a legal, business, financial, professional, or personal relationship with a party or witness in the same matter, or where the lawyer knows or should know that another party's lawyer is a spouse, parent, child, sibling, or lives with the lawyer, is a client of the lawyer, or another lawyer in the lawyer's firm, or has an intimate personal relationship with the lawyer. Even after getting consent or providing disclosure, the lawyer can only undertake the representation if they reasonably believe they will be able to provide competent and diligent representation to each affected client. The representation can't be prohibited by law, and the representation cannot involve the assertion of a claim by one client against another in the same litigation or other proceeding. And that's an important point to note. A lawyer can never represent one client against another in litigation or other proceeding. There's no disclosure or waiver that would allow that. If the necessary disclosures are precluded by another rule, such as the rule requiring lawyers to maintain client confidentiality, the representation cannot go forward. The underlying principle is that lawyers must be able to maintain independent judgment and offer their clients all options. If there is a situation that might restrict the lawyer's ability to do that, then there is a conflict. The comments to the rule note that clients in unrelated matters whose interests are only economically adverse, maybe because they're competitors, does not ordinarily constitute a conflict of interest. So bottom line, you need both clients' informed written consent to represent both if their interests are in any way directly adverse. You need informed written consent from each affected client if there is a risk that your representation might be materially limited based on just about anything. And you can never, even with informed written consent, represent adverse parties in the same lawsuit or tribunal proceeding, or in some other situations that are prohibited by law.